Hi, my name is Jim Sobak, and welcome to my office. For 27 years, I operated a high-volume bankruptcy practice across the state. And for the last 13 years, my office has been dedicated to automatic stay and discharge injunction violation cases. And the way this works is I've built a network of bankruptcy attorneys, bankruptcy law firms that refer automatic stay and discharge injunction violation cases to our office, and we represent your clients in these matters. And this video is designed to just give you an introduction to our approach, our procedures, and the way this thing works. So, to begin with, we have found that educating debtors is very critical in this entire process. Now, debtors come to us, they're overwhelmed, they're being hounded by creditors. There's a lot of things that they're being told. But one of the most important things, as we know, is the protection of the automatic stay. And it's very important that they understand how it works, what their rights are, and what to do if there is a violation. So what we've done is we've put together a brochure. And this brochure goes into great detail about what their rights are, what to do if they get a bill or an invoice or a summons, what to do if they get a phone call, and the importance of forwarding that information to your office. And we found that this makes a huge difference in stay violations. Many clients, because they're not sure what to do, just don't tell you about the violation. Obviously, we can't help them if they don't do that. So what some attorneys will do is they'll provide this at the first meeting. Sometimes they'll provide it when the debtor comes in to sign. Other law firms will give it to them at the 341 meeting. In any event, you put this in the hands of your clients, it very much enhances this entire program. And whenever you need more of these, you just call our office, and there's no charge, obviously, we provide them to you. So let's talk a little bit about our approach to stay violations and discharge injunction violations, because it's very different from the traditional approach. And I know what the traditional approach is because I did it for 27 years. Somebody comes in with a bill or a letter, you'll either tell them don't worry about it, or maybe you'll send a letter to the creditor, please stop, which they ignore. It's very ineffective. It doesn't really enforce the rights of the debtors, and we have a different approach. We do not send warning letters. Our position is the creditor has already been notified. Presuming that the creditor has been properly noticed, they're on the list, the address is correct, the 341 notice tells them exactly what they can and cannot do and what the consequences are if they take any action against the debtor. So this is the approach that former Chief Bankruptcy Judge Stephen D. Gerling took, and this is from one of his decisions, saying it's not the debtor's responsibility to take action to ensure that she receives the protection of the automatic stay. Rather, the creditor bears the burden of seeking relief from the automatic stay before taking post-petition collection actions. It's not the debtor's job to give notice because the debtor's already done that. This creditor is on the petition and they received notice. We had a case in which the defense was, hey, you have to shoot a warning shot across our bow before you file a motion. And this is what Judge Gerling said. Such a requirement would place an unreasonable burden on the debtor to forewarn the offending creditor to cease and desist before debtor's counsel could reasonably file a Code 362H motion. And that's the approach we take. You've already been warned, you violated the stay, you violated the rights of the debtor, and now it's time for consequences. So, once there's been a violation, we do one of two things. We file a motion, or we make contact with that creditor. Now, because we've been doing this since '06, we have many, many contacts with many, many creditors and law firms on the creditor's side. And we've litigated many, many cases. So our reputation is we're not bluffing. We will file a motion. We will litigate it if we have to. And what that's resulted in is that most of these cases are handled by email. When I first did this in '06, if you looked at the calendar, you would see all kinds of motions from our office. You won't see that anymore. Why is that? because most of these cases are settled without filing a motion because the creditor has a history with us and knows what we do, that we're very good at what we do, and we're not bluffing, and we settle these cases. Now, if there is a creditor that we haven't had contact with, and that does happen, we do file a motion. We do not send any kind of a warning letter. Our approach is to settle, not to litigate these things, not to run up attorney's fees. We think our demands for settlement are very reasonable. We filed a motion right off the bat without doing a lot of extra work. If you want to settle for this amount, it's over. We do not take the approach that simply because the statute gives us attorney's fees that we should then try to run this thing up and try the case just to run up fees. We don't do that. What are our procedures? How does it work at your end when your client comes in and says, look, I keep getting bills from this creditor? What happens? Well, first of all, you have to understand, we're taking work off your desk. Now, traditionally, if there's something going on, the lawyer says, look, you need to get this stopped. You got to make phone calls. You got to write letters. You don't have to do any of that anymore. You simply are going to refer the case to us. We do all the work. We determine if there's a violation. We contact the client. We file the motion if we have to. We make the contact. We settle the case. We do everything. So once you refer it to us, you're done. Referring cases, how do you refer the cases over to us? Well, you could mail all of the documents and the pertinent information to us here in Syracuse. You could email it to us if you wanted to. Or you could use our website, which is probably the most efficient way of doing it. So if you go to selbachlaw.com, at the home page, you'll see this attorney referral tab. You click on that and you get this form. Okay, client's name, all the pertinent information. There's a place down here where you could upload whatever documents you need. Important that we have the client's phone number because we will call the client when we get the referral. Once you fill this in, upload, and you click, you're done. You have nothing more to do. We take care of it. You could fax the documents if you want to. We do have some law firms that do that. We will then call the client. That's why we need the client's number. Explain who we are, what we're going to do for them, how the fees work. And that's really important because clients are like, is this going to cost me any money? No, it's not. If we collect nothing, you owe us nothing. Our fees come from the settlement. Your client will never pay us, which they're very happy to find that out. They're going to get some money, which they didn't anticipate. They're going to have the collection activity stopped, and it's not going to cost them anything. But we do need to call the client. There's a retainer agreement, and there's a fee sharing agreement. Because we're allowed to share fees with your law firm, there's some paperwork that has to be generated so this is done in an ethical and proper way. So the client will get the retainer agreement and the fee sharing agreement. Your office will get the fee sharing agreement, and you just have your attorney sign that and put it back in the mail to us. But we take care of everything else with the client. We send you the fee sharing documents, which I just talked to you about. Then the next thing that happens is you get a check, client gets a check, and the matter is closed. Let me tell you something about the clients. They're very pleased that somebody's doing something about this, and they're very pleased that they're getting money, which they didn't anticipate. Most of these debtors just want this to stop. And because they were told by the bankruptcy attorney, rightfully so, these people can't, bother you, can't do anything, all of a sudden it's happening. And if nothing's done, they think either the bankruptcy attorney didn't know what he was doing or there's something wrong with the bankruptcy code. There's nothing wrong with the bankruptcy code. There's nothing wrong with the bankruptcy attorney, but somebody needs to do something. And we get cards and letters and phone calls all the time saying, thank you so much for taking care of this for me. So it enhances your office and its perspective as well as ours. Client gets money, your office gets money. So those are some of the office procedures and the approaches. And if you have any questions, don't hesitate to call us here. And again, welcome to our firm.